Good afternoon and welcome to the 42 BR Barristers and the latest in our series of webinars addressing topical issues in family law. Anne and I are presenting this. I'm Gemma Taylor and this is Anne Osborne. We apologise for the postponement of this session. We are going to tell you or talk to you about disclosure in public law care proceedings. This is, in fact, the last webinar in this particular series. All the private, public and family remedies webinars can be found on our website and YouTube channel. I'm sure you can't wait to watch those later. Any questions that you have are to go in the QA box, which will be addressed at the end of the session if we have time, or we can follow up via email. And an email containing the recording and feedback form will be circulated over the next few days. We haven't handed out notes in advance of this talk. We'd like you just to listen and absorb the very useful information we hope to be giving you. But what we can provide is just a crib sheet with the main references that we're going to be giving you. I'm going to begin our talk with a few generalities. The court's powers to control disclosure and the local authority management of disclosure generally. Anne will then talk about the limitations on disclosure, how and when duties to disclose can be curtailed. These are the interesting cases where disclosure makes a real difference, often to the safety and well-being of the parties to proceedings and the subject children. They're the tricky matters that you don't always come across. We hope to highlight cases that you may not be familiar with, and we'll also speak about our duties as lawyers and what happens when there is inadvertent disclosure. I'll then talk a little about the fascinating topic of police and mobile phone disclosure, and Anne will conclude with the local authorities' duties of disclosure to third parties and in particular foreign authorities. We aim to conclude this fascinating talk in about 30 minutes. In fact, we found it quite interesting and we hope you enjoy what follows. So get your tea and a little notebook if you're keen and just listen. Firstly, the court's powers to control disclosure. These are found in the family proceedings rules. You'll be really familiar with the overriding objective, part 1.1 of the family proceedings rules, where the court is invited and must deal with cases in ways that are proportionate, etc. I remind you of Rule 4.13b, which is the court's general power of management to make such order for disclosure and inspection as it thinks fit. And of course, Rules Part 21 and Part 22. Part 21 of the family procedure rules sets out all the miscellaneous rules about disclosure and inspection of documents. Rule 22.1 deals with the control of evidence. This is where the court may control the evidence by giving directions as to the issues on which evidence is required, the nature of the evidence it requires to decide those issues, and the way in which the evidence is to be placed before the court. An important and useful example, which is rarely used, but I wish I'd known about it before, is the case of Re-R, secure editing of documents. It's a 2007 case, which involved the secure editing of documents, where the father in that case had already served a term of imprisonment for threatening to kill the mother. So there were really good grounds for her to be saying, actually, I'm really scared about this chap knowing where I live and where the children are. And Peter Jackson, Mr. Justice Peter Jackson, as he then was, gives a really helpful judgment and sets out effectively a crib sheet for what to do in advance of documents being prepared to ensure that accidents don't happen when documents aren't properly redacted. And the way to go about it is to identify or invite the court to identify in advance of documents being prepared, so this is at an early case management hearing, that this is such an exceptional case that documents should be securely edited in advance. So, for example, where there is an imperative need to keep matters confidential, you leave out addresses, you leave out names, you leave out the names of schools. And the court can apply special restrictions on how the documents are to be prepared. This is much safer than withholding or trying to redact information. It's all set out in paragraph 19, which also has helpful guidance on who should have responsibility for the preparation of these documents. And we'll touch on, I think, part 12 later, which is the sharing of information within about proceedings. I'm going to touch now really briefly on the local authorities' general duties to disclose. Outside proceedings, first of all, this will be really quick, just so that you are aware, whether by consent or not, or whatever the data protection rules say, where there are safeguarding issues, local authorities have a duty to share information. There are 7 golden rules for sharing information set out by the DFE guidance from July 2018. And practitioners can share information without consent if the safeguarding of children and individuals is at risk, if that condition is met. Moving on to what concerns us in care proceedings, the local authority documents and records in care proceedings. The local authority has a positive duty to disclose all relevant material in its possession, except that which is covered by public interest immunity, and whichever material might assist a parent in rebutting allegations against them. These are the cases of Hampshire, 1990, and Re-C, 1995. And as a general rule, disclosure should be made of documents recording factual matters of relevance, but not those recording opinions and advice. So when you're trawling through thousands of pages of ancient local authority records and you come across case management discussions, you can probably ignore those and just focus on the factual matters. That helpful advice is given in the case of Re and A and others, Child Abuse Guidelines 1992. So what happens in a care case where one or several of the parties or interveners has a significant history in care or otherwise, and the records that exist look pretty interesting? The test is relevance, because you don't automatically get disclosure of everything. That would be too onerous, cost a lot of money and take too much time. The leading case is Durham versus Dunn. It's a 2012 Court of Appeal case. And the case concerned an alleged assault on the claimant, an ex-child who'd been in a care home. And whilst in local authority care, this child had been significantly abused. And the child or ex-child was made a claim against the local authority in civil litigation. The defendant, local authority, sought to withhold the names of other children who had been at the home and who were potential witnesses. So it's obvious how sensitive this information was going to be. The judgment and guidance given by Lord Justices Kay and Mumby are invaluable. I invite you to read the judgment if you need to. And the relevant paragraphs are paragraphs 23 and 24. In summary, they provide that there should be disclosure only of relevant documents and that disclosure should only be denied if it's strictly necessary. Concerns about identifying third parties could be met by some limitations or restrictions, but again, only as strictly necessary. Redaction should only be allowed if, guess what, strictly necessary. And there must be a compelling reason to blank out the names of all non-parties. The case is a helpful reminder and gives guidance about the court being able to impose safeguards in an order that identifies non-parties, and for example, that they should only be identified to the parties and their advisors and should not be disclosed beyond that. And if a local authority is asked to provide for the disclosure of their records into court proceedings, this should be the subject to the terms of a done undertaking, limiting the documents to what is relevant only and limiting sight of the documents to specific classes of persons for the purposes of the case only. That would lead to significant savings in time and cost and avoid unnecessary redaction of documents. And Munby LJ confirmed that those seeking to withhold disclosure or redact social work records in litigation should analyse the issue in terms of the balance between competing rights under Article 6 and 8 and not in terms of public interest immunity. I recommend paragraph 23 and 24, but I'm not going to bore you with an imitation of Morris K. LJ. The import of criminal jurisprudence is confirmed in a case called R versus PO, Children, Similar Fact Evidence, 2021. And this is a case where the court found, and it's at paragraph 3, that the analysis in criminal cases and the family case and civil cases of exactly what is defined as relevant is the same. And the test that should be applied as to what is relevant is as follows. There are 2 questions that the judge must address in a case where there is a dispute about admission of evidence. First, is the evidence relevant as potentially making the matter requiring proof more or less probable? And if so, it will be admissible. Secondly, is it in the interest of justice for the evidence to be admitted? That was my whistle-stop tour of the basics. I'm now going to hand over to Anne for a much more interesting digestion of the particular examples of limitations. Anne.
Thank you, Gemma. So I'm going to deal with the provisions under Practice Direction 12C, specifically at paragraph 3.2. Under those provisions, the court can direct that there's an automatic notification of respondents of an application under Part 4 of the Children Act is not required. And that usually applies in exceptional cases. For example, the question of whether we notify fathers of proceedings. It has to be borne in mind that in exercising that provision, Articles 6 and 8 are likely to be engaged. Most of the cases that follow that provision usually have involved fathers being notified, but that is not by all means a blanket position. Where a parent tries to prevent a local authority from informing family members about the existence of a child, they would need to issue an application under Part 19 of the Family Procedure Rules 2010 to invoke the court's inherent jurisdiction. Again, there are a number of reasons that a parent might seek to do that. One of the instances might be the fear of embarrassment because they haven't told the family about the circumstances of the birth of a child. And that also arises frequently in relinquished babies cases. And there's where we'll pause for a moment. So Re-A is a relinquished baby case, the risk of domestic violence. It's a 2018 case. And Cobb J helpfully summarizes at paragraph 19 the factors that the court has to consider in determining whether or not that provision not to inform family members should be exercised. I won't go through the full list, but there is a very useful analysis of what the court needs to consider and how the court goes about applying that balance. And as I say, that's set out at paragraph 19 of that case. What we fall on is that there must be a high level of justification, and the court is required to weigh up all the relevant considerations in determining whether or not that notification should take place. Move on slightly to Re-C, and this is a 2018 case, and Cohen J adds to Cobb's analysis. And he adds 3 points onto that, and I'll take you through that briefly. What he says is that the remedy sought has to be exceptional, and therefore the circumstances needed to justify the remedy have to be exceptional. It doesn't have to be one exceptional factor. It may be a combination of circumstances. And none of them might be exceptional, but when they apply the aggregate test, that may add to the concept of exceptionality. But he also cautions about taking a holistic view and looking at the assessment and what is known of the family and what they might be able to offer before falling on a decision about what should happen next. So those two areas are very helpful in taking the mind through what needs to be satisfied, the approach that the court will take, and summarising the key pointers to be borne in mind. I want to move on, and I hope I'm not going too quickly, to the procedure for limiting disclosure. Most useful case that I can point you to is this is a secure editing of documents. It's a 2007 case, and it's helpfully set out in 7 or 8, 9 paragraphs what documents the court ought to consider. I'll start again. What the court should identify as falling in the category to be edited, the directions that should be given, specifying what sort of editing should take place, what information should be withheld, and whether it's appropriate to order documentary disclosure, bearing in mind the risks of that information being inadvertently compromised. The court has to bear in mind the avoidance of making unnecessarily wide orders, so it does have to be a focused exercise. And the chain of progression has to be spelt out, so it's quite clear about who is going to manage the editing of those documents. The responsibility of doing that can fall to one or more persons. The obvious candidates usually are the child solicitor, and there should always be a second editor. It should be fairly clear that the benefit of having this second editor is that where one misses one document, the other is going to pick up on it, and it avoids inadvertent disclosure. Once the editing process is being conducted, it should be conducted by someone who knows the details of the case and the importance of the task. That ensures that the key documents, most essential documents, are going to be the ones that are part of the process and appropriately disclosed and edited. As Gemma has already mentioned, this is about the management of the burdensome task, but also the cost implications. And of course, the procedure is tailored to the circumstances of the case. Then there's a further consideration for disclosure, which is the restriction of disclosure of information to third parties, so that includes family members. When I prepared this note, I did ask myself whether it's a bit confusing to say, well, there's no obligation of a local authority to notify family members, such as grandparents, about the existence of a child or to serve them with notice of proceedings, bearing in mind their wider duty to assess family members. But I paused for thought on that for some time. But these two principles can coexist. It's not saying that there isn't that wider duty to assess family members, but what it's saying is that actually, unless the family member is going to be assessed, there is no obligation to disclose that information. It has to be disclosure with purpose. So I'll move on to the slightly juicier bit, contempt of court, what you can and can't say to other people. So for the purposes of this section, the relevant bit that we look to is the Family Procedure Rules 2010, specifically Rule 12.731. And that sets out a fair list of what is deemed to be a contempt of court in terms of the communications and who you communicate with. And I'd like to take you through a few cases that really are illustrative of the provisions. So it's a case of far too soon. It's often the case that in marketing departments, they say, well, what juicy case have you got that we can stick on the website? Or people increasingly put things on their LinkedIn profile. And this is a case of a barrister who fell foul in that similar way. This is a 2023 case. I will send out the link to that case. And what he did is that he got the judgment and in a rather excited fashion shared it with the senior clerk, who had no idea that it was not to be circulated, released that judgment before it had been handed down or probably approved, and he found himself conducting a self-report for breach of confidentiality, contempt of court. There's a second case, and this is our Counsel General for Wales and the Secretary of State for Business and Energy and the Industrial Strategy. That's 2022 case. In this one, it's slightly more nuanced. The judgment was received with a clear rider, not to be disclosed before hand down, and the barristers involved in this case forwarded it to marketing about releasing it the next day without clarity about when the next day meant. Marketing responded saying, would you like me to put it on our intranet or the internet as well? And they said, we're not bothered, or words to that effect. And to be expedient, it was put on the Chamber's website that morning. Came to the attention of the Chamber's director that judgment hadn't actually been handed down yet. And so they had to report themselves for breach of confidentiality and contempt of court. There was a level of leniency exercised because it was recognised that under the pressure of the day dealing with other matters, they hadn't really addressed what was meant by release it the next day. They hadn't noticed that this member of staff hadn't understood the timeline appropriately. So I think the watchword for all of us is don't hand over judgments until we're told we can and under what circumstances we can do so. Perhaps I'm overly cautious, but I always pause before I send it on to a client, because once you've sent it to the client, you can't get it back. And clients frequently will want to discuss it with family members and other people, even though they shouldn't. So it's just a moment of pressing pause. The next interesting one is the dinner party conversations. I think we're probably all a little guilty of it, that you meet friends and what are you up to, anything interesting? And you might start roundly discussing a general principle of the case, not the detail of it, I would hope. But in this instance, this is Griffiths and Tickle and others, and it's 2022 case. The Silk in this case met with a friend of his wife's for dinner, and she happened to be a member of the ALC. He wanted to know whether the ALC might want to intervene in his case. She expressed her view that they might want to intervene. He invited her to write to the ALC and find out if they might want to do so, sending her his skeleton argument along with a copy of the draft judgment for them to make that determination. I think he'd also sent his draft appeal application. So there was quite a lot of information that she had access to. She didn't read it, but she forwarded it on to the ALC with a covering note. The ALC, quite rightly, informed the appeal parties that they had this confidential information. How it had come about, they were not entirely sure, but she identified herself and admitted her wrongdoing. The Silk, of course, found himself in some difficulty. Again, a level of leniency was applied. But it goes to show how we can sometimes bolt the stable with the expectation of doing the right thing, but sometimes the wrong way. And then last one that I wanted to touch on is YouTube. This is AG and Dowie in 2022. Mr. Dowie had been recording proceedings and placing them on YouTube, and he found himself detained at His Majesty's pleasure for his pains. There was less leniency applied to Mr. Dowie for his efforts. So then I'd like to move on a little bit to the communications to parties beyond proceedings. The Annex A to Practice Direction 12G provides very helpful table of what can be disclosed or communicated by whom and for what purpose beyond proceedings. It's quite a comprehensive table, and so I'd invite you to have a look at that. And moving on to Section 12 of the Administration of Justice Act 1960, that provides an automatic restriction for the disclosure of information in a number of circumstances. And it's useful to have a look at those restrictions. The analysis on this point is helpfully set out by Munby, as he then was in Re B, a child disclosure in 2004. The analysis still holds good. So the next bit that we might want to consider ourselves as practitioners is what we can and can't discuss with colleagues. Issues of confidentiality. We often find that it's useful for clarifying points and clarifying thinking to discuss a case with a colleague, or even just blowing off a little bit of steam about the frustration that sometimes arises in the difficult work that we do. But Family Procedure Rules 12.751A tells us that the disclosure of details in a case concerning a child where a confidential discussion is taking place to obtain support, advice, or assistance in the conduct of proceedings, that's fine. But it doesn't extend to subsequently discussing the details of the case with other colleagues. I think that that's the grey area that we need to be mindful of. One colleague's fine, but then cascading it out isn't so acceptable. There's a further automatic restriction on disclosure imposed under Section 97(2) of the Children Act, and that sets out in some short order what we can and can't do. Now, those restrictions can be dispensed with by the court where it's satisfied that the welfare of the child requires it, and I'd invite you to have a look at the case of Norfolk County Council and Webster and others, 2006. And there's a helpful analysis that Munby provides about those restrictions and how we apply it. So that concludes my bit about disclosure for now, and I'll hand you back to Gemma for police disclosure.
Thank you, and I'm really sorry it's not going to get much more interesting. You're all familiar, I hope, with the Family and Criminal Agencies and Jurisdictions 2024 protocol. The good news is I'm not going to go through that in any detail. Many of you would have already done some mini training about it. The bottom line is that the protocol now puts the onus really on local authorities pre-proceedings as they're preparing their proceedings to get their tackle in order to make their Appendix 1, I think it is, application. I probably got that wrong. Please don't write in. Application to the police where they can identify what documents they think are going to be relevant. So it's not a blanket application for disclosure. It's all about relevance. So look at the 2024 protocol. It supersedes the 2013 protocol. But I will now mention a couple of cases because we've all been in situations where, despite best efforts, we think we've got all the police disclosure we require, and yet something happens. Now, the first case is Lancashire versus A 2018 case. This is one of the first cases I actually did. I don't want to sound braggy, but it was a dead baby case, and we were in the middle of the case. And we knew that there'd been problems with police disclosure, and lo and behold, up popped a couple of really quite relevant witness statements, which we hadn't seen before, which led to an adjournment briefly and lots of hand wringing, etc. And we just carried on. And Mrs. Justice Knowles just carried on in her own implacable and polite way, but it wasn't a happy situation for any of us to be in. It simply wasn't fair, and everyone was running around a little like headless chickens. So Gwyneth Knowles provides in that judgment a very useful analysis of the rules for disclosure and inspection. She reminds us that there is a difference between disclosure and inspection. Disclosure being identifying what documents there are, inspection meaning actually reading the documents. She reminds us that the family proceedings rules don't really contain as much detailed information and guidance as to how really to get to the bottom of the disclosure issues. These are contained in the civil procedure rules. And so we should refer to the Civil Procedure Rules 1998 as appropriate. She also expressly endorsed the approach taken by Francis J. in the Re-L case of Re-L, a child 2017. I know this is some time ago, and fingers crossed, let's hope that with the new shiny new 2024 protocol, we won't need to resort to this. But I remind you of this 2017 decision because the police had simply abjectly failed repeatedly to comply with disclosure. And Francis J sets out some really helpful information as to how to manage a situation if your protocol request simply isn't being met, or you each all have a high suspicion that there other documents exist. I'm not going to read it all out, but there are very, very helpful and useful lists of how to ask the police for information, how to ask the family court to make directions that specify the information required, recommending that there are liaison meetings between the officer in charge and the local authority way before the fact-finding hearing, so that there can be clarity and an understanding as to what is actually going to be relevant. Because we all know that what the police think is relevant applies in their criminal cases, and it isn't always what's relevant in our family cases because of our wider canvas issues. The next matter I'm going to talk about briefly before Anne resumes is mobile phone disclosure. The main authority on this you may be familiar with. It's quite recent. It's PHL Children Mobile Phone Extraction 2023. Now, this is a case where the Court of Appeal considered an appeal on behalf of the Guardian from the direction made by the judge in the court below for evidence matters to provide an interrogation of a child's phone in circumstances where the allegations were that there had been some inappropriate sexual behavior by dad to child. And the father wanted to see all of his daughter's social media, all of her communications with her ex-boyfriend and all of her friends. Now, the Guardian raised the point was that there hadn't been third-party consent to this disclosure in advance. The Court of Appeal, mostly Baker J, says very clearly, and it's all set out. Let me just see what paragraphs have I identified. Look at paragraph 62, look at paragraph 65, look at paragraph 66 to 68. So the bottom line is, you don't need the consent of third parties before making these orders. These disclosure orders can be managed with undertakings and with clear understanding about the ownership of the information. What it actually says is that once you've established relevance, careful case management following the downloading of the material will ensure that following a sift by a lawyer appointed by the local authority, only relevant and appropriately redacted material will be disclosed to the court and to the parties. So get it all and then get some poor volunteer who knows about the case to sift and redact and take it from there. That's my short contribution. I'm now going to hand over for our final part to Anne.
So I'm going to, thank you, Gemma. I'm going to continue with the local authority duties on disclosure to foreign authorities. The reason that I thought this might be useful is I had a case, I think it was last year or maybe earlier this year, with a local authority who had notified and disclosed care proceedings to a foreign authority. An authority that has political issues and many of its citizens do not have the same liberties that we enjoy, which pressed pause in my mind for, was it appropriate to have disclosed that information before the proceedings had started, the wider implications for the subject child's family who was still in that jurisdiction, and what that might mean in terms of that child's emotional welfare for knowing that that disclosure had been made. And what the local authority told me when I first raised it was that they were under an absolute duty to make those disclosures. But I knew that that couldn't be quite right. And what Article 34 of the Hague Convention 1996 tells local authorities is that whilst they might be asked for information about a child, they do need to consider whether that disclosure places the risk, that child at risk or their property at risk, or is a risk to the family or the liberty of the family who remain in that foreign jurisdiction. Article 37 of the Vienna Convention on Consular Relations 1963 does require local authorities to notify foreign authorities of proceedings concerning their nationals or children within their custody. But that does not fall away from the requirement to consider the balance of risk of providing that notification. And what I think the takeaway is that local authorities ought not to blithely proceed with making those notifications until they have done that risk assessment. And it needs to be a careful risk assessment. That risk assessment may sometimes require that it is paused until proceedings start. The key case in this is the matter of Re-O, and this is a 2021 case. And it sets out at paragraphs 31, 32, and 33 that there isn't an absolute duty on local authorities. There will be circumstances in which it's wholly inimical to the welfare of the child to give that requisite notice. And whilst we would ordinarily comply with the convention requirements, it's sometimes appropriate not to do so. So how does the local authority get around that if they're concerned about the risk to them of being criticised for falling foul of the regulations? They bring the matter to court. They invite the court to make a declaration that they don't have to comply with that notification. And how does the court reach that conclusion? Whatever the grounds that the parent or the local authority relies on satisfy the concern that it would be inimical to the child's welfare, that must be set out in some detail. And in the absence of having sufficient information to perform that assessment, the court can and has required expert reports about the safety aspects, the implications for family or children outside those jurisdictions. Once the court has that information, it can then reach its conclusions about whether a local authority should or should not comply with the notification requirements. Whilst those steps are being taken, the court can provide recitals that say that the local authority should not share that information until that assessment has taken place. And that's very much where we left it with the case that I refer to. I hope that that's helpful I certainly also invite you to have a look at the guidance, the 2019 guidance of the International Family Justice Office, family courts informing consular authorities of proceedings. It's a very helpful guide about what the court might want to have a look at and what local authorities need to bear in mind. And it is a helpful read comparing that with the provisions in Re-O and how we approach these matters. If the horse is already bolted the stable, we can still press pause and require the local authority not to share further information until that assessment has been conducted and until the court has given its indication about whether there should be further notification of foreign authorities. So I think that brings my bit, the totality of the seminar to a close. And we thank you very much for joining us for our seminar. I hope that it has been useful to you. We will share the case notes so that you can have a look at the various cases. And if you have any questions, then you can follow them up by email. We can ask you to send them through to a general email box, which is events@42br.com. It's once again, events@42br.com. Thank you very much for coming, and we will look forward to seeing you at our upcoming autumn-winter series.
I'm told that will be sent out in the next few days. Thanks for your patience. We've overrun. So if you're still there, thank you and cheerio. Have a good evening.